Good day, sir. I'm Lady Guelgiano, third year Criminology Section Bravo, and in this video, I will read and summarize the Article 14 and 15 of the Revised Penal Code. So, Article 14, Aggravating Circumstances. The following are aggravating circumstances. Number 1, that advantage be taken by the offender of his public position. Requisites. Number 1, the offender is a public officer. Number 2, the commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. Essential, public officer use the influence, prestige, or ascendancy which his office gives him as the means by which he realizes his purpose. Failure in official is tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position. Number 2, that the crime be committed in contempt of or with insult to the public authorities. Requisites. Number 1, the offender knows that a public authority is present. Number 2, the public authority is engaged in the exercise of his functions. Number 3, the public authority is not the victim of the crime. Number 4, the public authority's presence did not prevent the criminal act. Example, Juan and Pedro are quarreling and the municipal mayor, upon passing by, attempts to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue the quarrel until Juan succeeds in killing Pedro. Person in authority, public authority who is directly vested with jurisdiction has the power to govern and execute the laws. Examples of persons in authority: governor, mayor, number 3, barangay captain, number 4, councilors, number 5, government agents, number 6, chief of police. Rule not applicable when committed in the presence of a mere agent. Agent subordinate public office charged with the maintenance of public order and protection and security of life and property. Example, barrio vice lieutenant and barrio councilman. Number 3, the fact be committed, number 1, with insult or in disregard of the respect due to the offended party on the account of his A, rank, B, age, C, sex, or number 2, that it be committed in the dwelling of the offended party if the latter has not given provocation. Circumstances, rank, age, sex may be taken into account only in crimes against persons or honor. It cannot be invoked in crimes against property. Rank, it refers to a high social position or standing by which determine one's pay and emoluments in any scale of comparison within a position. Age, the circumstance of lack of respect due to age applies in case where the victim is of tender age as well as of old age. Sex refers to the female sex, not to the male sex. Not applicable when, number 1, the offender acted with passion and obfuscation. Number 2, there exists a relation between the offender and the victim, but in case of divorce decrees where there is a direct bearing on their child, it is applicable. Number 3, the condition of being a woman is indispensable in the commission of the crime. Example, parricide, rape, abduction. Requisite of disregard to rank, age, or sex. Number 1, crimes must be against the victim's person or his honor. Number 2, there is deliberate intent to offend or insult the respect due to victim's rank, age, or sex. Disregard to rank, age, or sex is absorbed by treachery or abuse of strength. Dwelling must be a building or structure exclusively used for rest and comfort. Combination house and store not included. May be temporary as in the case of guests in a house or bed spacers. Basis for this is the sanctity of privacy the law accords to human abode. Dwelling includes dependencies, the foot of the staircase, and an enclosure under the house. Elements of the aggravating circumstance of dwelling Number 1, crime occurred in the dwelling of the victim. Number 2, no provocation on the part of the victim. Number 3, requisites for provocation. Requisites for provocation, all must concur. Number 1, given by the owner of the dwelling. Number 2, sufficient. Number 3, immediate to the commission of the crime. When dwelling may not be considered, when dwelling may and may not be considered. When it may be considered, although the offender fired the shot from the outside the house as long as his victim was inside, even if the killing took place outside the dwelling, so long as the commission began inside the dwelling. When adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the house. In robbery with violence against persons, robbery with homicide, abduction, or illegal detention, if the offended party has given provocation, if both the offender and the offended party are occupants of the same dwelling. In robbery with force upon things, it is inherent. When it may not be considered, the victim is outside his or her dwelling if offended party are not occupants of the said dwelling. Number 4, that the act be committed with 1, abuse of confidence, or 2, abuse, ungratefulness. Requisites of abuse of confidence: A, offended party has trusted the offender. B, offender abuse such trust. C, abuse of the confidence facilitate the commission of the crime. Requisites of ungratefulness: A, ungratefulness must be obvious, that is, there must be something which the offender should owe the victim with a debt of gratitude for. Note, robbery or theft committed by a visitor in the house of the offended party is aggravated by obvious ungratefulness. Example, a jealous lover, already determined to kill his sweetheart, invited her for a ride, and during that ride he stabbed her. Abuse of confidence is inherent in number 1, malversation. Number 2, qualified theft. Number 3, estafa by conversion. Number 4, misappropriation. Number 5, qualified seduction. Number 5, that the crime be committed in the place of the chief executive or in his presence, or when public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Requirements of the aggravating circumstance of public office. A polling precinct is a public office during election day. Nature of the public office should not be taken into account like a police station, which is not duty for 24 hours a day. Place of the commission of the felony. Paragraph 5, it is the Malacanang Palace or church is aggravating regardless of whether state or official functions are being held. As regards other place where public authorities are engaged in the discharge of their duties, there must be some performance of public functions. The offender must have intention to commit a crime when he entered the place. Requisites: the aggravating circumstances for place of worship. Number 1, the crime occurred in the public office. Number 2, public authorities are actually performing their public duties. Number 3, the crime occurred in a place dedicated to the worship of God regardless of religion. Number 4, offender must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 of Article 14 are applicable. Committed in the presence of the chief executive in the presidential palace or a place of worship. Paragraph 5, Article 14, public authorities are performing of their duties when the crime is committed. When crime is committed in a public office, the officer must be performing his duties except in the presidential palace. Public authority may be the offended party. Committed in contempt of public authority. Paragraph 2, Article 14, same outside the office or still performing duty. Public authority is not be the offended party. 6A, that the crime be committed in 1, the night time, or 2, in an inhabited place, or 3, by a ban whenever such circumstance may facilitate the commission of the offense. Nighttime and uninhabited place, or by a ban aggravating when impunity means to prevent the accused being recognized or to secure himself against detection or punishment Night time begins at the end of dusk and ending at dawn, from sunset to sunrise. Uninhabited place, one where there are no houses at all, a place at a considerable distance from town where the houses are scattered at a great distance from each other. 1. It facilitates the commission of the crime. 2. Especially sought for the offender to ensure the commission of the crime or for the purpose of the impunity. 4. Commission of the crime must have begun and accomplished at night time. 5. Commission of the crime must begin and be accomplished in the night time. 6. When the place of the crime is illuminated by light, nighttime is not aggravating. 7. Absorbed by treachery. Requisites: the place facilitate the commission or omission of the crime. 2. Deliberately sought and not incidental to the commission or the omission of the crime. 3. Taken advantage of for the purpose of impunity. What should be considered here is whether the place of the commission of the offense where there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than 3 armed malefactors have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Requisites: if one of the 4 armed malefactors is a principal by inducement, they do not form band because it is undoubtedly connoted that he had no direct participation. Band is inherent in robbery committed in band and brigandage. It is not considered in the crime of rape. It has been applied in treason and in robbery with homicide. 1. Facilitated in the commission of crime. 2. Deliberately sought. 3. Taken advantage of for the purpose of impunity. There must be 4 or more armed men. Number 7, that the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Requisites: number 1, committed when there is a calamity or misfortune. Number 2, conflagration. Number 3, shipwreck. Number 4, epidemic. Number 5, offender took advantage of the state of confusion or chaotic condition from such misfortune. Basis: commission of crime adds to the suffering by taking advantage of the misfortune. Based on time, offender must take advantage of the calamity or misfortune. Distinction between paragraph 7 and 12 of Article 14, committed during a calamity or misfortune. Crime is committed during any of the calamities, committed with the use of wasteful means. Crime is committed by using fire, inundation, explosion, or wasteful means. 8. That the crime be committed with the aid of 1 armed man or 2 persons who ensure or afford impunity. Based on the means and ways, requisite: number 1, that the armed man or person took part in the commission of the crime directly or indirectly. Number 2, that the accused availed himself of their aid or relied upon them when the crime was committed. Exceptions: number 1, when both the attacking party and the party attack were equally armed, not present when the accused as well as those who cooperated with him in the commission of the crime acted under the same plan and for the same purpose. Casual presence, or when the offender did not avail himself of any of their aid nor did not knowingly count upon their assistance in the commission of the crime. With the aid of armed men present, even if one of the offenders merely relied on their aid, actual aid is not necessary. By a band requires more than 3 armed malefactors who all acted together in the commission of an offense. If there are more than 3 armed men, aid of armed men is absorbed in the employment of a band. 9. That the accused is a recidivist. Recidivist, one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime, embraced in the same title of the revised penal code. Basis: greater perversity of the offender as shown by his inclination to commit crimes. Requisites: number 1, offender is on trial for an offense. Number 2, he was previously convicted by final judgment of another crime. Number 3, the both The first and the second offenses are embraced in the same title of the revised penal code. Number 4, the offender is convicted of the new offense. Recidivism must be taken into account no matter how many years have intervened between the first and second felonies. Pardon does not obliterate the facts that accused was a recidivist, but amnesty extinguishes the penalty and its effects. To provoke recidivism, it must be alleged to the information with the attached certified copies of the sentences rendered against the accused. Exception is if the accused does not object and when he admits in his confession and on the witness stand. Number 10, that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty. Reiteration or habitually, it is essential that the offender be previously punished, that he has served sentence. Paragraph 10 speaks of penalty attached to the offense, not the penalty actually imposed. Reiteration necessary that the offender shall have served out his sentence for the first sentence. Previous and subsequent offenses must not be embraced in the same title of the code, not always an aggravating circumstance. Recidivism, enough that final judgment has been rendered in the first offense. Same title, always aggravating. Habitual delinquency, when a person within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification is found guilty of any said crimes, a third crime or oftener. Quasi-recidivism, any person who shall commit a felony that after having convicted by final judgment before beginning to serve such sentence or while serving the same shall be punished by the maximum period of the penalty prescribed by law. For the new felony, 4 forms of repetition. Number 1, recidivism, generic. Number 2, reiteration or habituality, generic. Number 3, multiple recidivism or habitual delinquency, extraordinary aggravating. Number 4, quasi-recidivism, special aggravating. 11. That the crime be committed in consideration of a prize, reward, or promise. Requisite at least 2 principles. Number 1, the principle by inducement. Number 2, the principle by direct participation. Number 3, the prize, reward, or promise should be previous to and in consideration of the commission of the criminal act. Applicable to both principles. Number 12, the crime be committed by means of inundation, fire, poison, explosion, stranding a vessel, or intentional damage thereto, or derailment of locomotive, or by use of any other artifice involving great waste or ruin. Requisite, the wasteful means were used by the offender to accomplish a criminal purpose. Number 13, that the act committed with evident premeditation. Essence of premeditation, the execution of the criminal act must be preceded by cool thought and reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. Requisites: number 1, the time when the offender determined to commit the crime. Number 2, an act manifestly indicating that the culprit has clung to his determination. Number 3, a sufficient lapse of time between of his act and to allow his conscience to overcome the resolution of his will. Conspiracy generally presupposes premeditation. When victim is different from the intended, premeditation is not aggravating, although it is not necessary that there is a plan to kill a particular person for premeditation to exist. Plan to kill first 2 person, one meets general attack on a village for as long as it was planned. The premeditation must be based upon external facts and must be evident, not merely suspected, indicating deliberate planning. Evident premeditation is inherent in robbery, adultery, theft, estafa, falsification, and etc. Number 14, that 1, craft, 2, fraud, 3, disguise be employed. Craft involves intellectual trickery and cunning on the part of the accused. It is employed as a scheme in the execution of the crime. Accused pretended to be members of the constabulary accused in order to perpetrate rape. Used chocolates containing drugs. Fraud includes insidious words or machinations used to induce victim to act in a manner which would enable the offender to carry out his design. As distinguished from craft, which involves acts done in order not to arouse the suspicion of the victim, fraud involves a direct inducement through entrapping or beguiling language or machinations. This number 2, disguise, resorting to any device to conceal identity. Purpose of concealing identity is a must. Distinction between craft, fraud, and disguise. Craft involves the use of intellectual trickery and cunning to arouse suspicion of the victim. Fraud involves the use of direct inducement by insidious words or machinations. Disguise involves the use of device to conceal identity. Requisites: the offender must have actually taken advantage of craft, fraud, or disguise to facilitate the commission of the crime. Inherent in estafa and falsification. Number 15, what that one advantage be taken of superior strength, or two means be employed to weaken the defense. To purposely use excessive force out of the proportion to the means of defense available to the person attacked. Requisite of means to weaken defense: means were purposely sought to weaken the defense of the victim to resist the assault. The means used not totally eliminate possible defense of the victim, otherwise it will fall treachery. To weaken the defense illustrated in the case where one struggling with another suddenly throws cloak over the head of his opponent, and while in this said situation, he wounds or kills him. Other means of weakening the defense would be intoxication or disabling through the senses, casting dirt of sand upon the other eyes. Versus by a banned circumstance of abuse superior strength, what is taken into account is not number of aggressors, nor the fact that they are armed, but the relative physical might be the offended party. 16, that the act be committed with treachery, alevosha. Treachery when the offender commits any of the crime against the person, employing means, methods, or forms in the execution thereof which tend directly and especially to ensure its execution without risk to himself, arising the defense which the offended party might make. Requisites: that at the time of the attack the victim was not in the position to defend himself. 2, that the offender consciously adopted a particular means, method, or form to attack employed by him. Treachery can't be considered when there is no evidence that the accused prior that the moment of the killing resolved to commit the crime. There is no proof that the death of the victim was the result of meditation, calculation, or reflection. Examples: victim asleep or half awake or just awakened, victim grappling or being held, stuck from behind. Treachery means, methods, of forms are employed by the offender to make it impossible or hard for the offended party to put sort of resistance. Abuse of superior strength: offender does not employ means, methods, of forms of attack. He only takes advantage of his superior strength. Means employed to weaken defense: means are employed, but it only materially weakens the resisting power of the offended party. Where there is conspiracy, treachery, or is considered against all the offenders, treachery absorbs abuse of strength, aid of armament by a man, means to weaken the defense. Number 17, that the means be employed or circumstances brought about which add ignominy to the natural effects of the acts. Ignominy is a circumstance pertaining to the moral order which adds disgrace and oblique to the material injury caused by the crime. Requisites: crime must be against chastity, less serious physical injuries, light or grave coercion, and murder. Number 2, circumstance made the crime more humiliating and shameful for the victim. Examples: accuse, embrace, and kiss the offended party not out of lust but out of anger in front of many people. Rape in front of the husband, rape successfully by 5 men, tend to make the effects of the crime more humiliating. Ignominy not present where the victim was already dead when such acts were committed against his body or person. 18. That the crime be committed after an unlawful entry. Unlawful entry when an entrance is affected by a way not intended for the purpose meant to affect entrance and does not exit. Why aggravating one acts not respecting the walls erected by men to guard their property and provide for their personal safety shows their greater perseverity, a greater audacity, and hence the law punishes him with more severity. Example: rapist gains entrance through the window, inherent trespass to dwelling, robbery with force upon things, and robbery with violence or intimidation against persons. 19. That as means to the commission of the crime, wall, roof, door, or window broken. Requisites: a wall, roof, window, or door was broken. 2. They were broken to effect entrance, applicable if only if such acts were done by offender to effect entrance. 2. When the crime be committed: 1. With the aid of person under 15 years of age. 2. Or by means of motor vehicles, airships, or other similar means. Example: who 1 instructed a 14-year-old to climb up the fence, open the gate for him so he may rob the house. Reason: the counteract the great facilities found by modern criminals instead means to commit crime and the flee to abscond. Once the same is committed, necessary that the motor vehicle be an important tool to the consummation of the crime, bicycles not included. Example: Juan and Pedro in committing theft used a truck to haul the appliances from the mansion. Number 1, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Cruelty: when the culprit enjoys and delights in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the consummation of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of the deceased, has to be proven. Number 1, mere plurality of words do not show cruelty. No cruelty when the other wrong was done after the victim was dead. Requisites: that 1, the injury caused be deliberately increased by causing other wrong. Number 2, that the other wrong be unnecessary for the execution of the purpose of the offender. Ignominy: moral suffering subjected to humiliation. Cruelty: physical suffering. So, Article 14 is aggravating circumstances. When you say aggravating circumstances, those circumstances which raise the penalty of a crime for a crime without exceeding the maximum applicable to that crime. So aggravating circumstances has 21 aggravating circumstances. So the first one is that advantage be taken by the offender of his public position. So the offender is a public officer. Then number 2, that the crime committed in contempt or with insult to public authority. So the offender is the public authority. And number 3, with insult or disregard of the respect due to the offended party on account of his rank, age, sex, that is committed in the dwelling of the offended party if the latter has not given provocation. So number 4, that the act committed with 1, abuse of confidence, or 2, abuse ungratefulness. So this is taking advantage of an example of this is taking advantage of a trust. For example, your friend trusted you but you decided to kill him. So that is an example of number 4, that the act committed with 1, abuse of confidence or obvious ungratefulness. Number 5, that the crime be committed in the place of chief executive or in his presence or when the public authorities are engaged in the discharge of their duties or in a place dedicated to religious worship. Number 6, there are 2, that the crime committed in the night time or in an inhabited place by a ban whenever its circumstances may facilitate the commission of the offense. And the second is whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. 7, that the crime be committed on the occasion of conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Example of this is when if there's an epidemic and you decided to commit a crime. So that is under the paragraph 7. So number 8, that the crime be committed with the aid of armed men or 2 person who ensure or afford impunity. And number 9, that the accused is recidivist. Number 10, that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty. For 2 or more crimes, it attaches lighter penalty. And 11, the crime is committed consideration of a price or reward or a promise. Example of this is meaning of this is you killed A because B promised you to give you a big amount of money. And number 12, the crime be committed by means of inundation, fire, poison, explosion, stranding a vessel, or intentional damage thereto, or derailment of locomotive, or by use of any artifice involving waste or ruin. 13, that the act be committed with evident premeditation. 14, that one craft or fraud or disguise be employed. 15, that the advantage be taken superior strength or means employed to the weakened defense. 16, that the act committed with treachery, alevosía. 17, that the means be employed or circumstances brought about which add ignominy to the natural effects of the acts. 18, that the crime be committed after an unlawful entry. 19, that as means to the commission of the crime a wall, roof, door, or window be broken. 20, that the crime be committed with the aid of person under 15 years of age, or 2, by means of motor vehicles, airship, or other similar means. 21, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary its commission. So that are the 21 aggravating circumstances of Article 14. Article 15, alternative circumstances. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating. According to the nature and effects of the crime and the other conditions attending its commission, they are the relationship and intoxication and the greater of instruction and education of the offender. The alternative circumstance of relationship shall be taken into consideration when the offended party in the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister or relative by affinity in the same degrees of the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstance. The intoxication of the offender shall be taken into consideration as mitigating circumstance when the offender committed a felony in state of intoxication if the same is not habitual or subsequent to the plan to commit said felony, but when the aggravating intoxication is habitual or intentional, it shall be considered as an aggravating circumstance. Alternative circumstance, those which must be taken into consideration as the aggravating or mitigating mitigating according to the nature and effects of the crime and other conditions attending its commission. They are: number 1, relationship, taken into consideration when offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister relatively by affinity in the same degree of the offender. Intoxication. And number 2, intoxication, mitigating when the offender has committed a felony with a state of intoxication if the same is not habitual or subsequent to the plan to commit said felony. Aggravating, habitual, or intentional. Number 3, degree of instruction and education of the offender. Relationship, mitigating circumstance in crimes against property, robbery, usurpation, fraudulent, insolvents, or arson. Exception, Article 332 of CC. No criminal liability only for the crimes of theft, swindling, or malicious mischief committed or caused mutually by spouse, ascendants, descendants, or relative by affinity. Also, brothers, sisters, brothers-in-law, or brothers-in-law if living together. It becomes exempting circumstance. Aggravating circumstance in crimes against person in cases where the offender or when the offender and the offended party are relatives of the same level as killing a brother, adopted brother, or half-brother. Always aggravating in crimes against chastity. Relationship, neither mitigating nor aggravating when relationship is an element of the offense. Example, parricide, adultery, concubinage. Intoxication, mitigating circumstance. Intoxication is not habitual. B, if intoxication is not subsequent to the plan to commit a felony. Aggravating circumstance. A, if intoxication is habitual, such habit must be actual confirmed. B, if it's intentional subsequent to the plan to commit a felony, must show that he has taken such quantity as to blur his reasons and deprive of him certain degree of control. A habitual drunkard is given to inebriety or the excessive use of intoxicating drinks. Habitual drunkenness must be shown to the actual confirmed habit of the offender, but not necessarily of the daily occurrence. Degree of instruction and education, mitigating circumstance, low degree of instruction, education, or the lack of it, because he does not fully realize the consequence of his criminal act, not just mere illiteracy, but lack of intelligence. Aggravating circumstance, high degree of instruction and education, offender avails himself of his learning in committing the offense, determined by the court, must consider the circumstance of lack instruction. Exceptions not mitigating: number 1, crimes against property; 2, crimes against chastity, rape included; 3, crime of treason. Take note of the abbreviation GMAA, Article 11 to 15. Article 15, alternative circumstance. This means that this depends on the circumstance will depends in the relationship, intoxication, degree of instruction of the education. It depends of the mitigating or aggravating circumstances. So in alternative circumstances, there are 3: the relationship, 3 to consider the relationship, intoxication, and degree of instruction and education. And each of these 3 has its own mitigating and aggravating circumstances. It depends on the crime committed and the relationship, intoxication, degree of instruction, and education. So this ends my reading activity and reading and summary activity of the Article 14 and 15 of the Revised Penal Code. Again, I'm Lady Chalgalgiano, 3rd year BS Criminology, Section Bravo. Thank you.